We can start.
Hi, everyone. Welcome to Green Card with Yehi. We have today with us, we have Greg, Green Card with Greg, and myself. My name is Soraya. We are both managing attorneys at Yehi and Associates. We are lawyers that practice immigration law. We practice family law. We practice personal injury law, labor law. So we have 3 offices, physical offices in Queens. We have an office in Jackson Heights and Jamaica and Ozone Park. Today, we're going to be talking about I-601A waivers, when they're needed, what's required, and some developments that have been going on with respect to 601A waivers. So I know we do have some questions from our viewers, and we can get started on talking about waivers. So generally speaking, when a person applies for a green card or wants to apply for a green card, there are certain requirements that have to be met, which are referred to as admissibilities. Sometimes a person may be inadmissible because they either came to the United States unlawfully, meaning they came in through the border without being inspected, without going through a port of entry. Or, for example, if a person has overstayed their visa in the United States, and they're not married to a U.S. citizen or have an immediate relative petitioning for them. So for those reasons, they may need a waiver to excuse those wrongdoings, to excuse those immigration violations. Specifically, in general, a person has to return to their home country in order to get their green card. To have the privilege of applying for your green card in the United States, you have to meet a host of requirements. One of them being you have to have been inspected. That means you have to have come through a port of entry, and you must have been seen by an immigration officer. Many of our clients do not meet that requirement. And in those cases, those clients are, fall into kind of a conundrum, because if they leave the United States in order to go to the embassy for their green card interview, they will be triggering what's called a 10-year bar, a 3 or 10-year bar, depending on how long they've overstayed in the United States. So there's a solution for that. Greg, would you like to talk about what a person in those circumstances could do?
Absolutely. So the 601A waiver started with the Obama administration, I believe, because people would either, if they were forced to leave, they're gone for 10 years, 3 or 10 years, or they would just stay. So they had to find an option, some form of a relief for these people who are otherwise able to gain legal residency. In our office, it is by far the most common we do. We have people come in all the time. They're eligible for, or otherwise eligible for legal permanent residency, but they have an entry issue. They crossed the border illegally 5, 10, 20 years ago. And now they're married to a U.S. citizen, they have a family here, they own a business, and they would like to get a green card, gain legal status. So what the waiver does is it forgives the way you entered the country or your unlawful presence, which we'll get to later. But most of the time it has to, like when we do it, it has to do with entry. People enter the country, cross the border without a visa or inspection. So to qualify for this waiver, you have to have all the, you have to satisfy all the other requirements for legal permanent residency. And then you submit this after your I-130 petition, and it'll hopefully get approved. Then you leave the United States, go back to your home country most of the time, go back to your home country and get your green card through consular processing at the Department of State. But to qualify for the 601A waiver, you need to show hardship, extreme and unusual hardship, to only your parents or spouse who are lawful permanent residents or citizens. Does not work for your children, your brother, anyone else. You have to have a U.S. citizen spouse or parent or legal permanent resident parents to show extreme hardship to. Is that a good summary, sir?
Yeah, that's exactly what it is. Yeah, so like you said, it's a 3-step process. If you qualify for the 601A waiver, if that's a good option for you, which you would need to speak to an attorney to discuss whether or not that is a good option for you. It's a 3-step process, as Greg described. So the first step is a petition. Step 1, you have to have the U.S. citizen or green card holder relative that's willing to petition for you. So that's step 1. Step 2 is the waiver, the 601A waiver. Once your I-130 petition is approved, then you file your 601A waiver. Once your 601A waiver is approved, then you move on to step 3. And step 3 is where you actually apply for your visa. And that's done through the Department of State, through their National Visa Center, and it's usually done through their online filing system, application system, which is called CEAC, which that in itself is a whole nother topic. We could talk about just the NVC process itself. So that is step 3. And then once all those 3 steps are completed, the NVC will send your case to your local embassy, whichever embassy you chose. Usually it's the person's home country, the embassy, the US embassy in their home country. They will send your file, your application to that embassy, and then that embassy will schedule you for an interview according to their normal process. And that is when you leave for your interview. Most of our clients are gone for approximately 2 to 3 weeks. They go to their home country, they get their medical done by the civil surgeon in their home country, by the approved doctor, and then they go for their interview. And with respect to our clients, all of our clients have returned with the exception of one. The reason you may not come back is because you did not disclose something. You have to tell your lawyer everything. So in that case, the client did not disclose a criminal, something related to their criminal history. So because that was not disclosed, we had to work around that. And we did work around that, and they did come back. So all of our clients did come back. But that is, generally speaking, the process. 99% of cases, the client comes back. Okay, so we're not saying that this is a risk-free way to get the green card. There, of course, there's always risks associated with any immigration application, and again, that's something that you should discuss with your lawyer to see if that is the best option for you, and what the risk is for somebody in your situation. So that is the process. Now, Greg discussed what is the standard to get a 601A waiver approved, and that standard is extreme and unusual hardship. So what does that mean? So that could mean that as Greg described earlier, it has to be your US citizen or green card holder parent or spouse. We'll call them the qualifying relative. In the immigration world, that's what they're known as, qualifying relatives. So your qualifying relative has to show that they would suffer from extreme hardship if they had to stay in the United States without you, or if they had to go to your home country and live there with you. So they have to show hardship in both situations. And what does that mean? What kinds of hardship can they show? There's many different kinds. So Greg, if you want to talk about what kinds of hardship the qualifying relative can show.
Yes, so it can be anything from financial, emotional, physical hardship. The first thing I look for is medical problems. We have several, there are several clients, their spouse has cancer and needs company while they're undergoing treatment. I have other clients with little kids who don't know the language in their native country, cannot go back, or need help with school. They need their parents, or excuse me, because they're not a qualifying relative, but they have.
But that can be an indirect hardship to the
To
qualifying.
the spouse, yes, to the spouse. Their spouse doesn't have time to take care of the children who have special needs. Thank you, Soraya. They have anything from financial needs. We have one client who runs his father's company, and the company will go bankrupt without him. There's many different ways. Usually we recommend your qualifying relatives, spouse or parents, to get a psychological evaluation to better delineate the specific problems they will have if they're forced to leave or be without their qualifying relative. But medical, financial, emotional, severe hardship is.
That's also what I've seen. So for financial hardship, what that means is that whether the qualifying relative is a breadwinner or not, there will be some impact to the qualifying relative. So for example, let's say the qualifying relative is a US citizen wife, and she, not to get into stereotypes, but let's say she stays at home with the kids. She manages the home, takes care, makes sure the kids are, do their homework and go to school on time, and that they're well, they have their meals. So in that case, the hardship would be that if the waiver applicant were to be deported, or if the qualifying relative had to return, they would not have the financial income of the applicant. Let's just call them the beneficiary. They would not have the income, the benefit of having the applicant bring home, financial help for the family. So that would be how we would, frame the argument in that case. And if it were the other way around, and that the 601A applicant stayed at home and took care of the kids and, managed the household, we would argue that they would not have, I'm sorry, that they would not have, they would not be able to do that, but for the help of the beneficiary. So I may have mixed that up somewhere. I'm not sure, but regardless, we can analyze everyone's situation and argue what works, what makes sense and what works for them. And the way that we show the financial hardship is we'll ask client for all their bills, their mortgage, their lease, their phone bill, their utility bill, their doctor's bills, any kind of bill that you can think of, we would submit that to show the financial hardship. So yeah, that's another form of hardship that the applicant could use to apply for the 601A waiver. So so another update in the world of 601A waivers is that there's been huge delays in adjudicating those types of cases. So generally speaking, it's been very rare for us, or I believe other practitioners can also agree, for us to see any decision on 601A waivers since January 2020. So since then, no one has seen a decision on a 601A waiver.
That's incredible.
Yeah, that's crazy. So there has been some class action litigation filed on this issue. They had an open call period if you wanted to join as part of that litigation. I'm not sure if they extended that time, but it may have closed. But there is litigation on this topic. Why is it taking so long for immigration to decide these cases? And it's mostly, of course, due to, you know, the pandemic that we had. But regardless, I think we've moved, it's still going on, but I think we've moved on from the worst of it. So it's unusual that USCIS has not decided many of these cases since then. Yeah, so
What are some other issues? So the thing I tell clients is, please do not worry. Many of the issues I see with our clients is that they've been in the United States for such a long time, and they are extremely fearful they will not be able to return.
yeah.
So please do not worry. We have many, as Soraya discussed, we've had one single client at Getty & Associates that wasn't allowed to come back. Now, past results don't guarantee future results, but if it is approved, you are extremely likely to come back, okay? Many of our clients use it as an opportunity to see their family that haven't seen in years, show their children the country they're from. If it's approved, there's a most certain chance you will get back, okay?
Right.
Without promising, clearly.
Of course. We never promise any results
Never
here.
promise anything. Okay, I tell clients, the only thing I can promise is good communication. I can't make
That's
this
right.
fast, but I can promise to be in good communication and to explain the process to you. The other issue I see is people come to us after they've tried it themselves. They are living in the country, they're married to a US citizen, and they try to do what's we call just a straightforward adjustment of status. And the I-130 petition is approved, but the 485 green card application gets denied because they don't have that entry. So we have a lot of people walk in the office that I don't understand. The petition was approved. My wife's a US citizen. We went to the interview, but I still don't have my green card. In this case, we need to do what's called a I-824. And I'm bringing this up because Soraya had to explain it to me about a dozen times before I understood it. When I first joined.
And now you're a pro. Now you know all
Yes,
about it.
now I'm giving, yeah. So hopefully I won't get it wrong. You won't have to correct me another time. But what happens when you file your I-130 petition for alien relative, you have to say where they plan on applying for their green card, all right? Whether it's going to be abroad at a consulate or whether it's going to be here at USCIS. So if you mark the box or write, Brooklyn, New York, or New York, New York, the Department of State, which is different from Homeland Security, doesn't know about this approved petition. So you'll have to file what's called an I-824, and they'll transfer, so it's these two separate organizations can communicate with one another. And then that'll go to the consulate, and then you file a 601A, now that the NVC has. Did I explain that, or was that a little too,
That's exactly what it is. Yeah,
is that a
got
little
it.
bit too much in the weeds?
No, that's exactly what it is.
But the audience has to understand, I'm trying to impress Raya with how much he's taught me, so if I seem a little bit too, pedantic, that's
It-
why.
yeah, it's worked. A+.
Okay,
Okay, so yeah, those are some practical issues of this waiver. A lot of our clients and not just clients, people we consult with, they are very scared at the prospect of returning, of going back to, of leaving the United States because, they know about the bar. They know that they won't be able to get in. They know that they won't be able to get in if they leave. But again, this is something you want to speak to your to an attorney about to make sure it's something that could work for you. But that's what this waiver was created for. That's what former President Obama created this waiver for, is for people in these situations where they were eligible for a green card, but they couldn't get it because of this technicality in the law. So it was created for people in these situations. So I really recommend that you speak to an attorney about the process to make sure it's right for you, to guide you through the process, because it can get very technical. The law changes every day. So it's something you definitely want to speak to an attorney about. What about?
yes,
Mhm.
oh, sorry. I completely agree with Soraya. Please, for this, get an attorney. We also have many cases that are in immigration court, and the relief would be adjustment of status if it weren't for the entry issue. So it gets, immigration law can seem simple, but it gets real complicated real quickly. And when you have this waiver, we have clients that are in immigration court, which is the Department of Justice, have their petition with USCIS, which is Homeland Security, and then you have the waiver through the NVC, which is Department of State. So you have three separate bureaucracies that don't like speaking to each other. Any mistakes made, it could take years more, be even more of a hassle. Please, that's what you hire a lawyer for, is to take care of this.
Absolutely. So what about cases where, let's say the client or a person has somebody to petition for them, for example, a US citizen son or daughter that's over 21, but they don't have a qualifying relative. What can you do in those cases? So there's many people that are in this unfortunate situation where they have a petitioner, but they don't have a qualifying relative, which, as we discussed, is either a spouse or a parent who is a US citizen or green card holder. So in those cases, there are some other alternatives that can be considered for them to still apply for their green card. And there's two ways. The first one of which is if they are what's called grandfathered. When somebody is grandfathered, that means that either an employer or a family member filed a petition for them on or before April 30th, 2001. So that can be an I-130 petition. It could be a labor petition. It could be the preliminary step to filing a labor petition, which is a perm. And it could be for them or their parent, which would make them a derivative beneficiary for grandfathering. So that would be one workaround if a person does not have a qualifying relative. The second workaround would be what's called parole in place. So, excuse me. So that means that parole in place is a benefit to members in the military. So if you have an immediate relative, a spouse, a child, or a parent in the US military, you can apply for parole in place, and that will give you an I-94, which will in turn allow you to apply for your green card in the United States. So those are the two workarounds for the 601A waiver if you do not have a qualifying relative. So I mean, that's pretty much it. 601A waiver in a nutshell. Is there anything that you want to add, Greg, or we could move on to questions from any viewers if there are any?
Yeah, we could definitely move on to questions. I think that we've covered a lot in a short amount of time.
Yeah.
Are there any other, if you have TPS, you can also, or DACA, you can also get
Yes,
parole.
absolutely.
To get good entry. It's a little bit more risky, but definitely you can do it. So those are other options.
Those are other options.
Yeah, let's take some questions.
Let's see.
So I overstayed a US visa and I'm a US citizen. Do I need a 601 waiver? Very important. Do not get the 601A waiver confused with the 601. Totally different things. 601 cures many things from fraud to medical issues to 601A is for unlawful presence or unlawful entry. Maybe one thing we did forget to mention is that it cures unlawful presence, because we don't deal with it as much. But say your mother petitioned, you came to the United States with a visa, and your parents or your brother petitioned for you. You have unlawful presence because you've overstayed your visa, which would usually be waived if your child or your spouse petitioned for you. But if your parents petitioned for you, it's not waived. The good news is you have a qualifying relative. So if you came here, overstayed your visa, and your parents petitioned for you, you can use the 601A waiver to cure that. We also have clients that, for one reason or another, their spouse cannot become a US citizen, but they're legal permanent residents. Their spouse petitioned for them, their unlawful presence is not waived. They came, but their unlawful presence is not waived. And so either the spouse needs to become a citizen and they can't, they need the 601A waiver. And the good news is they have a qualifying relative. So back to the question. I overstayed a visa and I'm marrying a US citizen. Do I need a 601A? If you entered the country legally through a port of entry with a visa, you do not need one. It will be waived. It will be waived. We do have some cases where the visas were taken away. There are other complications, but this is very rare. If you entered with a visa, you overstayed, you married a US citizen, you do not need a waiver. Soraya, you want to take the next one?
Yeah, that's exactly right. So let's go to the next question. If the 601A waiver is approved, does that mean I have legal status to stay in the United States? No, it does not. It does not. It's just a waiver, which says, if it's approved, it says that your unlawful presence or your unlawful entry is waived. You will not be subject to the 3-year or the 10-year bar if and when you try to return to the United States. So that's all the waiver does. It does not give any type of legal status to stay in the United States. So the next question is, will the termination of my conditional lawful permanent resident status affect my 601A waiver validity? I'm not really understanding that question, because those are two different processes. So maybe we misunderstood the question. We'll move on to the next one. If my provisional waiver is approved, does that mean I will get my visa once I depart the United States? That's what we're hoping. That's what we're hoping. Nothing in life is ever guaranteed. But that's what we're hoping for, is that once it's approved and you go to your consular interview, that your visa will be approved at your visa interview, and that you'll be able to come back. You have to do a whole visa interview. So you'll be seeing a consular officer, and of course they will be making sure you meet all the requirements to get a visa. So you will have to complete that process. Okay, can I leave the United States before biometrics collection? No, you cannot leave the United States unless you have a approved waiver and an appointment, fixed appointment at the embassy. You should not be leaving. In that case, you should be talking to your attorney. Your attorney will advise you when the right time to leave is. What will happen to me if my provisional waiver application is denied or withdrawn? Will I be placed in removal proceedings? That is a tough question, because of course only the government knows their own policies, and if they want to change them at any given time. But we have not, in my experience, and Greg, you can also confirm that in our experience, we have not seen anyone be put into removal proceedings when their 601A waiver is denied. Knock on wood, we have not seen that. So yeah.
You could have problems if you're in proceedings and they're on pause due to your 601A waiver application not being approved, because then you don't have relief.
Yeah, and if the person is in removal proceedings, of course, there are certain things that need to be done within the removal proceeding before you can file your 601A waiver. You want to take the next question, Greg?
Okay, can I file another new 601A waiver if my prior application has been denied? Yes, but once again, there must be a reason why it was denied. I tell a client, what's Einstein's definition of insanity? You're doing the same thing over and over again and expecting different results. We'd have to do it differently. Maybe you had a relative you didn't include. Maybe you just didn't provide enough evidence. But yes, we can, we have people come in, say, I tried to do it on my own, it was denied, now I'm nervous. That's what we're here for. Okay, is to do it again, to do it the right way. But yes, you can reapply.
Yeah. All right, so we'll take 2 more questions.
Is premium process available?
No.
Sorry.
No.
I can't make things go faster.
Right.
If you have an attorney that promises they can make it go faster, Soraya will hire him immediately. Okay, if that's possible.
Yeah.
Yes, we we can promise we will work hard, we will work fast. We love this country, we love the government. The immigration law isn't known for its efficiency.
No,
I hope I didn't misspeak.
no, if any government official is watching this,
Yes.
thank you. Thank
It's a
you
government
for your
bureaucracy.
service.
Yes.
Okay, one last question. What should I do if my 601A waiver is approved during removal proceedings? That is probably legally impossible, because a 601A waiver will not be approved when you have open removal proceedings. So it was most likely an error. So you definitely want to talk to an attorney about that. Okay, so there was,
But if you're in, one of the reasons, if you're in removal proceedings, we ask for dismissal, either through motion or through joint motion. It's called prosecutorial discretion, to get you out of the proceedings. So you can apply for a 601A. But they keep, if you're, it's sometimes. Sorry, I believe, correct me if I'm wrong, but can you leave your case administratively closed while you're applying for it and then dismiss, leave for consular processing?
I feel like I knew this off the top of time. I believe it has to be terminated.
It has to be terminated. Okay.
It cannot be administratively closed, so it has to be terminated before you file your 601A waiver.
Okay. So it has to be terminated. So,
Right.
but if you're eligible for a 601A waiver, it's a really good reason to give to the judge, to give to Homeland Security, to get you out of court. Okay?
Yeah, yep. Okay, so those are all very good questions. And we'd love to answer any questions that you might have. Please come see us. Please come talk to us to see if the 601A waiver is the right option for you. We are open. The Ozone Park office is open on Monday through Friday and Saturdays. Jamaica office is also open Monday through Friday and Saturdays. The Jackson Heights office is open 7 days a week. So we are here for you. Please give us a call at any one of the numbers listed on the screen. You're welcome to email us, visit our website, call us and schedule a consultation. We do virtual consultations. We have clients all over the world. So we would love to work with you. Yeah, and just a reminder, nothing that was said in this webinar is meant to be legal advice for any particular case. This is general information regarding immigration law, and it's not meant to be relied on for any one particular case because every case is different. You should talk about your case with an experienced immigration attorney before making any decisions. Okay, thank you for joining us, and we hope to see you next week. And thank you. Bye.
Thank you all.